Greetings. This is Attorney Della Welch, W-E-L-C-H. I have been 42 years an attorney in California, and I'm also a member inactive of the Utah Bar. I practiced in Utah for many years. So what I'm going to talk about today is how to respond to a petition to renew a DVRO order. The good news is when I graduated and passed the bar in 1982, there were no self-help clinics in California. But I'm happy to report that there's many very successful self-help clinics. I'm familiar with the Riverside Superior Court and the San Bernardino courts, and they have wonderful self-help clinics that will help you. So take advantage of that. Now you can Google certain forms for your response. The first form is Google capital D, capital V, 720. That's your response form that must be filed. And then you can Google DV250. And what that is the proof of service form to file your response. And I will talk more about that. And then you can Google DV730, and that's the order. The order, the judge can renew the DVRO for a certain time period, or he can deny the renewal. That's the issue. If you want any further relief, you'd have to file a request for order, which is the form request for order. You can check with your courts on that one. Now, once you receive the request to renew the DVRO, I would suggest that you look procedurally. Are there any procedural errors? Now, in the underlying DVRO pleadings, I found on the case of Mr. Doe that the pleadings were not signed by the attorney. Well, that creates a problem of authentication. At the hearing, I will raise the fact the pleadings cannot be properly authenticated, and I will object to their admission in court. The second thing I found is he attached various exhibits with a declaration explaining why he wanted the DVRO renewed, but he made a serious mistake. None of that was referred to, adequately described, attached, and incorporated by reference. Therefore, he filed a nothing burger. And I will be raising this at the court hearing, the procedural errors. Also, when you do consider your response, you may want to consider who do you want as a witness. And there is a witness list. It's FL321, and you can Google that, and then that will give you a blank list, and you can file that list with the court. Should be filed 5 days before the hearing. And if you have any declarations, be sure and attach them, adequately refer to them, and incorporate them by reference, or you can be subject to a motion to strike. Now let's look. What is the basis for a renewal? How do you oppose that basis? So there's various decisions that say, well, we're filing this petition because we have a genuine, reasonable fear of further harm by the respondent or the petitioner or whoever. And then you can also say, there's been a changed circumstance. I always start my opening argument by good news and bad news. The good news has become great news, and we have a changed circumstance of a wonderful remarriage and a new family. So that would be a basis not to renew. There's clear decision in the Ashby decision as that is a basis not to renew. And in the case I'm working on, they didn't state their basis to renew, which was hearsay, until about 4 pages into the information. So when you're filing a petition, you have a 10-page limit. When you're sending the opposition, you have a 5-page. So you're going to have to say it all in 5 pages. That doesn't include exhibits, but remember to refer to them, adequately describe, and incorporate by reference. So you can research that. I like the Rutter, R-U-T-T-E-R, book in family law. When I practiced heavily in family law, that was the Bible. Everything you went there. Now we have Google, and I see a lot of articles on Google in family law. There's local law libraries in the area. I know that San Bernardino has an excellent law library. In Orange County, in Santa Ana, there's a wonderful law library there. So check your local directories. In downtown LA, I went many times to the law library on First Street. So those are good available sources. So remember to do that. Now, after you complete your DV 720, you may want to attach a declaration stating your reasons for denying that, asking the court to deny that, and be sure and attach and incorporate by reference. So after you do that, make sure you date it and you sign it. If you're represented by an attorney, make sure he dates it and signs it. And then I would make an original and 2 copies because you're going to want to be handling them, and I'll explain to you how you do that. You fill out a DV 250 form, which is the proof of service. And the person who completes that must be over 18 and must live in the county where they're currently mailing it. They have to put the date and the place where they send it, and they have to sign it. So they have to sign a copy of everything and put it in the mail and send it. And you'll get more details in DV 250 on how to do that. And also, you can go to the court self-help here areas, and they are extremely helpful if you have any questions. There's also a general help number called 211. If you're having any problems, be free to call that. That's all free to you. So after you get your response in, then you'll be given a court hearing date. Often the DVRO petition comes with a court date. On the one I appeared at, I appeared on the date stated, but they had a problem. The judge was ill, so we had to be given a different date and given priority. But at the hearing, prepare for an opening argument. And I always say good news and bad news, and state your good news. And also look at the underlying order. I said the bad news on my case for the other side, other than they didn't sign it and properly incorporate the exhibits and didn't clearly state their objection reason, is the underlying order said the person had no visitation with their children because they were emotional abuser. It's not just physical, it can be emotional. But he was required to take no courses such as anger management. Plus, he was given no supervised visitation. Well, it's well known that prisoners get visitation. So he was worse than a prisoner. And if you read the headlines, Brad Pitt, Angelina Jolie, and all of those are involved in these DVRO and parental alienation, Alex Baldwin. So it's making the news. In California, there's a law called PIQUI that requires all judges in the state of California to be trained in parental alienation. And the underlying order in my case, he obviously wasn't trained. He said he didn't know the loyalty contract, didn't know the target parent, so he lacked the fundamentals. So it should fall on its own. It's like dead bones that should never be permitted to rise again. So I talk about how you have an opening argument, and then the other side has the burden of proof. The petitioner has the burden of proof. And if they found their burden of proof, then you've got to go to your information. But you're entitled to cross-examine witnesses. In my case of Mr. Doe, he has a child, it's a seminary graduate, very religious. And I can say, now you had good times with your father. Isn't that correct? Make every question a leading question. Isn't it true you went to the Laker game together? Isn't that correct? Isn't it true you were there when Kobe Bryant had his problem and you were very close to your father? So stress the good times and say, as a religious person, you've been taught to honor your father and mother. And how does that relate to your desire to testify against your father today? So ask the leading questions, and then at the end of the hearing on the DVRO, you're able to make a closing argument and practice your opening and closing argument. On Mr. Doe's case, I'm going to argue a great injustice has been done here. An order was made denying any visitation to the father without a judge even understanding parental alienation, without a judge even giving visitation. And the result of the order is very contradictory. They're having it both ways. He's so bad that he's an emotional abuser, and yet he's not bad enough for courses. Look at common sense. Common sense and reasonableness are the most important thing. They're offering some Facebook articles, and yet they're old and stale and irrelevant. Be prepared with your objections. And again, go to the self-help clinics. They're a great help. They weren't available in '82, and I think that's one of the great developments. I was recently at court, and I saw people with filing the divorce forms, and they were getting that help, and you're not thrown to the wolves with your needing to fill out forms. In law school, they send attorneys two things: a librarian, where you go find the law, and a form filler outer. And the courts are very helpful on form filler outer. And you can research the law, know what you have to prove, and practice. Practice makes perfect. If I do a closing argument, I may have practiced it 100 times. I can't wait till I get there to make my arguments. So hopefully this is helpful to you when you file a response, and hopefully you're very successful in court. We're not a perfect justice system, but we're the best in the world. There is no other court system as good as the American one. So I've been 42 years an attorney. I've loved every minute, and I count it a great privilege to be a member of the California Bar. This will be the end of the recording.